first case to come before the court today is in re adoption of M.G.S. Each party will have up to 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of time. The arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourself. You shouldn't use names of children or minors or victims should that be relevant to your argument. And the judges have certainly read your briefs and we're ready to proceed when you are. And I would just ask appellant's counsel, would you like to reserve time for rebuttal?
Yes, Your Honor.
And how much time?
5 minutes, please.
5 minutes, okay, then we are ready to go when you are.
Okay, thank you. Thank you, Your Honors. May it please the court, Attorney Angie Killey on behalf of the appellant Nathan Jera. The question for the court's consideration today is whether father failed to have at least de minimis contact with his child during the 1-year statutory period without justifiable cause. And I would urge the court to find that the answer to that question is that there was justifiable cause. So no, he did not have only de minimis contact during the statutory period without cause. We did make some arguments, Your Honors, in regards to de minimis contact. However, I want to focus my arguments today for the court on the justifiable cause issue, as it is our position that this is almost like a storybook case of a non-custodial parent being the reason for, a custodial parent being the reason for a non-custodial parent to not have a healthy relationship with their child. The relevant facts would indicate that these two were never married. Child was born on 3/26 of 2012, and for the next 4 years, father enjoyed regular visitation and companionship with his child. All the parties testified and agreed that there was a good relationship between parent and child during this time frame. There was no court order for this visitation. It was something that had been worked out between the two parties. At one point, there was a filing, but it was dismissed by agreement of the parties because they were willing to work together to raise this child. Father did have a child support order put in place, which he had been paying, and financial support is not an issue in this case. And it's my understanding that he continued to pay all through these proceedings. Sometime in the year of 2016, mother met and moved in with the current petitioner, who is now her husband. During that same year, companionship and communication with my client was stopped, and it was stopped by the custodial parent, not by my client. Over the next years, there was testimony that would indicate that father did attempt to make at least text contact through mother's phone to the minor child, and that he did in fact send gifts and other items through his mother. And I think that it is extremely telling in this case that the grandmother, my client's mother, has been afforded regular routine companionship time with this child since birth. So there is definitely a relationship with my client's side of the family that I believe is important to be preserved. However, with father, there's no indication that any of those messages were relayed, and there was actually testimony that they did not tell the child that the gifts that were coming were from him because there was fear that mother would retaliate and refuse to allow grandma to visit with the child as well. There was, the courts in this state have held that deprivation by a non-custodial parent to enjoy meaningful companionship with their child and has actively interfered with attempts, however meager those attempts may be. And I think in this instance, when you're saying however meager those attempts may be, even father attempting to text this child to wish it a happy birthday, in order to wish a happy holiday or whatever it may be, and mom absolutely refusing to give that information to the child, is significant interference.
Was your client able to produce the text below that he claims he tried to send to the child?
I'm sorry,
Was your client able to produce the texts below?
I don't believe there were any texts submitted into evidence, no, Your Honor. I don't believe that any of them were submitted into evidence, no. It was through testimony alone.
Counsel, I have a question.
Yes,
In
ma'am.
regard to grandmother, was there a set visitation schedule or just whenever?
I believe that it was just by agreement of the parties between the mother and the grandmother.
Okay. The other thing is, did grandmother have the child's supplement?
I don't know the answer to that.
Nobody questioned the grandmother about that or anything?
I don't recall there being any testimony about whether or not grandma had the child's cell phone From my understanding, it appeared as though grandma had a very open, warm relationship with the child and communication with her.
I was just wondering because, there's some discussion by both sides as to whether the father didn't even have the cell phone number to contact the child directly. And that, the argument is he didn't have it because mom didn't give it to him. And her argument is, no, he didn't ask for it. So I just wondered if he could have it from his mom.
I suppose my position on that would probably be, even though there's no testimony to the effect that there was testimony that they were afraid to tell the child the gifts were from him, so I have to assume his mother wouldn't have given it to him if she had the luxury of having the child's cell phone, because she didn't want to do anything to interfere. And I actually think that the grandmother is an important party to this action in the respect that the mother's willingness to allow grandma to have a relationship with this child, to me, is a clear indication of her vindictiveness in preventing the father. Clearly, she doesn't have a problem with letting other people see this child, but she was able to articulate no legitimate reason as to why he shouldn't be allowed to see this child.
Well, my understanding, the record showed that when father ran into the child, she said, yes, you can see the child, you need to go to co-parenting classes and get some counseling and learn to do those things. And he took no action to do any of that.
And I suppose my counter argument to that, Your Honor, respectfully would be, how does she have the authority to dictate whether or not they need co-parenting counseling? There was no professional involved in this case that came in and said that there was any detriment to this child that required there to be a mental health professional involved in reunifying, shall we say, parent and child. There was no indication and no factual basis that this child had any fear of her father. In fact,
There was an incident at Walmart where she hid from father when they saw each other, and that was what led to the cause of saying, perhaps there should be some reunification counseling, because in fact, you haven't seen your child in approximately 6 or 7 years.
And it had been a number of years since the child had seen him at that time frame, and it could be that the child was just shy and hides behind everybody's legs. I mean, grandma testified that she asks about her father, and that she inquires about when she is visiting with grandma, and gives no indication that there's fear. And our position would be, when you're talking about something as significant as terminating the parental rights of a parent against their consent, that perhaps she could, if she was very interested in having this parent-child relationship preserved, or even attempting to allow it to take place, take the child to a therapist, have that therapist determine whether or not there is a need for something like that, and move forward. Like one individual who has clear animosity towards my client, indicating that she feels this is the only acceptable way for them to begin to have communication again, and that communication was stopped because mother stopped letting him visit in 2016. She stopped the train and then wants him to take extra steps.
Is that clear that that would happen, or did father stop visiting on his own?
There is definitely a dispute on that one.
Yes, sir.
Yeah, there is. There is a dispute on that one, but I do
Did the
think.
trial court make findings as to that dispute, or did they leave it up in the air?
I don't recall the trial court making specific findings as it relates to that. And if I'm mistaken on that, I apologize, but I don't recall that, and I don't want to misspeak.
Okay, that's understandable.
Okay. And I guess I want to go back to grandma for just a moment, because even though, and I didn't mention it in my brief, but of course the court is able to make that jump. When we're talking about something as severe as terminating a parent's rights, I think we also need to take into consideration the simple fact that a termination of father's parental rights equates to a termination, legal termination, of all access to his entire side of the family. Which means that if mother is preventing dad from seeing, regardless of what she's done for the past decade, as soon as this adoption is finalized, there is no legal basis for grandma to be able to step in and say that I have a lifelong relationship with this child and I should be able to see it, because it severs the entire side of the family. In my opinion, based on my experience, I would say that grandma would probably be entitled to visitation rights if she were to petition a court based on the amount of time that she's been spending with this child since birth. And I think that when the court is looking at something this extreme, that they need to take the whole into consideration and not just this one individual, because there is a huge domino effect as it relates to the rest of the family. You look like you want to ask me something.
No, I'm just.
Oh, okay. Okay. But in furtherance, the other thing that I wanted to discuss is that mother testified at the hearing under questioning by father's counsel. She was specifically asked, would you allow father to order Girl Scout cookies for this child? No. Would you permit him to attend a softball game? No. Would you permit his wife to see the child? No. Would you allow father to visit with the child with his mother? No. Would you not, that she would not allow grandma to take the child to family events where there was a chance that the father could be present? And the court made a finding that this was not an indication of her blocking dad because it was pure speculation. And I disagree. These are specific instances where she was asked. This is her testimony saying, no, I would not allow this. She would not allow any type of contact, even under the supervision of his entire family, unless he bowed to her demand of having counseling.
Counsel, I know the ones you're talking about are hypotheticals, but is it disputed that, that grandma was told by mom that she couldn't have dad at the visits? Or is
And I
that
just
disputed
want to
as
let
well?
you know that you are, I'm sorry, Judge Carr, that you are moving into your rebuttal.
That's fine. I want to, well, make sure I answer your question. Okay, was it disputed that, my recollection is that grandma said that it was not permitted and mom said she would not allow it, so I don't recall there being any dispute in the record that she would not permit that. And I guess with that, then I will rest and reserve the rest of it, whatever I have left for rebuttal.
Good morning. May it please the court, my name is Attorney Paige Kern, and I represent appellee Stephen Shannon, who is the stepfather of the minor child. Mr. Shannon filed a petition to adopt the minor child with the consent of the child's mother, Heather Shannon, in the Summit County Probate Court on January 5th, 2022. The probate court found that the consent of Nathan M.G.S, the biological father of the minor child, was not necessary in order for the adoption to proceed, and father claims that the probate court erred in making that finding. But the probate court's decision was correct, and there are two main reasons why. First, father failed to provide more than de minimis contact with the minor child during the relevant statutory look-back period, which was from January 5th, 2021 to January 5th, 2022. And second, father was without justifiable cause for that failure. Before I expand on those reasons, I just want to briefly clarify the relevant law and standards of review. There are two exceptions to the consent requirement, that you need consent for the natural parents of the minor child who's the subject of an adoption petition. And you only need one of those two exceptions. There's only one exception here, but it clearly applies that there's clear and convincing evidence that the parent failed without justifiable cause to provide more than de minimis contact with the minor child.
Counsel, do you agree with the last question I asked, that the evidence was that mom did tell grandmother, paternal grandmother, that she was not allowed to have father there?
So they were hypothetical situations, and mom's answer was no, because I don't think the minor child would be comfortable with it, but if we could do something, get her to a point where she's comfortable, then yes, it wasn't just a flat no.
So the answer is that mom never testified that she would not allow father to be present with grandmother, never instructed grandmother that?
I don't believe so, because there were occasions where she did. I know there was a time when father ran into grandmother and the child at a fair in 2019, and that visit was allowed.
Well, mom didn't know about that though, right?
No, but afterwards she didn't stop grandma's visitation. I think it was more about just making sure.
Was there any evidence as to when she found out about the visit?
I don't remember.
Thank you.
So this exception technically has two parts, and each part has a different standard of review. The part of the exception regarding whether a parent had more than de minimis contact is reviewed for abuse of discretion, meaning that the trial court's decision was unreasonable, arbitrary, or unconscionable, and the decision regarding whether a parent had justifiable cause for that failure will not be reviewed unless the determination is against the manifest weight of the evidence. So I'll just briefly go
Why is
over.
abuse of discretion for de minimis?
I'm sorry.
I'm sorry, I'm trying to figure this out too, because this was a little confusing to me.
In the
So-
briefs.
So I'm trying to figure out, why would it be abuse of discretion for de minimis?
It is not. Oh, yeah, it is. That is from in re adoption of M.D., and that's an Ohio case. Just it has a lower standard because I think you get to that second part, and the justifiable cause is the more important one, so that is a manifest weight of the evidence standard. And that's from in re adoption of SMC.
Thank you.
So I just want to reiterate that revised code 3107.07A, which has those exceptions, says that the parent must fail to provide more than de minimis contact. It doesn't require a complete absence of communication between the parent and the child. So father argues that he sometimes gave the child gifts without anyone telling the child that they were from him, or that he ran into the child at a Walmart. And even though he admits that none of that was meaningful contact, he still says it should count because it technically wasn't no contact, and that's not what the statute requires. The
This
statute,
is a little unusual case because most of the cases that we get, there's really almost no involvement in respect to financial and or contact. And this is a little unusual for a father to maintain, payments for child support without any arrearages or anything.
but that's where the revised code 3107.07A comes in, because it says that you only need one of those exceptions. So while he may have been paying child support, if he wasn't providing some quality contact with the child, then him paying support doesn't necessarily matter, and his consent can still be found to be unnecessary. So the focus is whether he had quality contact with the child. And the statute doesn't specifically define more than de minimis contact, but there's significant case law, which is in the briefs that I'm sure that you've read, that holds it to mean contact beyond a single occurrence, whether that's attempted or actual contact. And the specific phrasing of that carries an implication that the focus is on quality contact, not necessarily any particular quantity of contact. So while one-time contact is definitely not enough, there's no specific number of contacts that constitutes more than de minimis. It's about the parent actually putting in some solid effort to have communication and contact with their child, and that just didn't happen here. There's an argument for 2 instances of contact during the relevant 1-year period before the filing of the adoption petition. The first is a run-in at Walmart where the child was scared of father because she didn't recognize him, and father conceded that there was no
And what year
meaningful
was that?
contact.
What year was it?
That was during 2021.
And child didn't recognize him after being with him in 2019?
She was scared of him. She didn't really know who he was.
That before or after the filing of adoption, I could not determine that from the record, do you know?
I believe it was before, because it was during the look-back period.
Okay, thank you.
But there was no effort in that interaction. The run-in wasn't planned. Father didn't know the child was going to be at Walmart. There was no intention to see her that day. And then the second instance was when mother texted father to get his consent for a passport for the minor child, and father replied that he'd only consent if he could see the child. And he admitted at trial that he only said that because mother reached out to him first and that he wouldn't have initiated that contact on his own. So again, there's no effort there, it's not meaningful, it's not quality, it's lazy, and it's not more than de minimis contact, especially considering father never followed up on any of mother's attempts to make that visitation happen after his request.
Well, a question that Judge Stevenson asked and the father's counsel replied to, isn't that a good point, that how does mother control visitation, say, and put the parameters on it?
I think it's a misconstrual of what she was saying. It wasn't conditioned. She never said, you can't have visitation unless we do therapy. It was more of, I know the child, I've been in the child's life, I think this would be helpful. What do you think? And father never responded to that. Father just kind of ignored her request.
Well, she said, I just won't get her passport signed then, since she won't agree to it, and I'm going to tell her that father was the one that caused her not to be willing to travel.
I think that she had suggested some of the co-parenting stuff, and father just never responded.
Well, didn't she, so that's not an evidence that she said, I won't worry about the signature then, since you won't agree to the parameters, and then I'll just tell the daughter that she won't be able to go because of that.
I don't really think, I feel like phrasing it that way makes it a demand.
Well,
I don't
what
think
did
that
they say
would
then? What did she say then about that? Because I don't mean to misphrase it, because I'm going to be completing all of everything myself and haven't done so yet.
Right, I don't remember, but I don't think anything was said. I think she just texted, father, this is my ideas for repairing that relationship. I don't think he ever responded. So I think there was the conversation was never really finished.
All right, thank you.
But then, so going more into that issue of whether father had justifiable cause for his failure to communicate with the minor child. This is where I want to note the presumption in favor of the finder of fact, because the trial court is in the best position to weigh the evidence, especially the credibility of the witnesses and the accuracy of their testimony. And I want to stress that because the trial court did not find Father credible regarding this issue. Father made several arguments for justifiable cause, and they all failed for ultimately lack of credibility. First, there was a lot of focus on hypotheticals. Father claims he couldn't have the child's phone number, but he admitted he never asked for it. Father claims mother wouldn't let him go to the child's softball games, but he never asked or tried to go. Father claims he sent the child gifts through his mother, but he never told the child the gifts were from him because he thought mother wouldn't let the child keep them. But he never tested that assumption by saying a gift was from him and seeing what would happen. And mother never said or did anything to make him believe she wouldn't let the child keep gifts that were from him. So there was so much testimony about these hypothetical situations that didn't happen, and the trial court properly acknowledged that as speculative, but Father still is trying to claim that it's specific instances of interferences when he had no actual proof or support for any of that. And then he also had a lot of false statements and contradictions in his testimony. For example, he claimed mother blocked his phone number, but then he mentioned text conversations with mother and eventually retracted that claim. He says he texted mother often about the minor child and mother never responded, but then the only conversations that he could produce were conversations where mother was receptive to communicating and he was the one who didn't respond. He claimed mother wouldn't let the child see his other children, even though he only apparently asked once and mother did allow it. Father blamed his visitation with the child stopping because mother moved in with stepfather, even though that happened after his visitation stopped and was completely unrelated. But then when mother testified, the father was the one who stopped visitation because of his work schedule, and I think some conflict with his, at the time, fiance. Father didn't have an explanation for that. He said he couldn't exercise visitation because he couldn't afford to feed the child, but then mother offered to send her with food, and father still said no, and then didn't have another excuse. So there was a lot of credibility issues. And then there was also a lot of emphasis on financial hardship as a potential justified cause. Father said that he thought he needed an attorney to gain his visitation and he couldn't afford one, so that should be justified cause for not trying to communicate with the minor child. And I want to note that at trial, Father admitted that belief was unwarranted because he never tried to figure out what his rights were, even though he could have made some phone calls or done some internet research for free. But that's irrelevant because Father never once said that he was saving up for an attorney or that he planned to get one. So the financial hardship thing kind of seems like an excuse that was just made in hindsight. But either way, beyond that, he didn't need court-ordered visitation because mother was willing to let him see the child without a court order if he would have just put in a tiny bit of effort to do so. And that's where Father's main claim of significant interference comes in. Both parents agree the child was scared of Father, she hadn't seen him in years, and Father can claim that he had a great relationship with the child in 2016 or that he had great relationships with his other kids, but that's not relevant. The reality of the situation during the 1 year period prior to the filing for the adoption petition is that Father didn't have a relationship with the minor child and needed to rebuild that. And mother was completely supportive of that. She provided numerous resources to facilitate communication between the father and the child. She suggested a plan for Father to ease back into the child's life by meeting in public places first. She offered to pay for counseling for the father and the child. She offered to pay for co-parenting classes. And Father even testified that he told his mom he was willing to do that, but he never responded to any of mother's repeated offers, and now wants to claim that it's significant interference.
Counsel, I'm just wondering, with the hypotheticals, did mom explain why she wouldn't have allowed those things?
Because the child wasn't comfortable. With the, are you talking about the Girl Scout cookies and stuff? Just, she wanted the child to be comfortable, and the child wasn't comfortable. She was scared of Father.
Even with Girl Scout cookies?
I think that was just one in a long line of hypotheticals, and she was just giving the same rote answer to everything.
All right, thank you.
But she encouraged a relationship with him constantly and tried to facilitate it in a way that the child was comfortable with. Because she knew the child. She knew what would make the child comfortable, and Father didn't. So that's not significant interference. Father may not have liked mother's ideas, but he never communicated them. He never suggested ideas of his own. He never responded to mother's encouragement because it required effort, and that's not something he was willing to give the child.
Other than the situation when mom called about the passport, were there other instances in the record of father asking for a visitation and mom being denied, and mom denying the visitation?
No. And going to father, or the child's relationship with grandma, I think that's just further proof that mom didn't have any negativity toward father and his family. She didn't have a problem with father's mother exercising visitation with the child, and grandma had a great relationship with the minor child because she asked for one. She put in the effort, father didn't. And there's also no evidence that that relationship would stop if the adoption petition was granted. I don't think mother wants to just rip grandmother away when grandmother's been in the child's life, grandma wants to be there, grandma's putting in the effort. So
Legally, will grandmother have the ability to visit after the adoption order goes through?
there was no evidence that she wouldn't.
Legally, not that de facto, but as a matter of law, would she have the right to have any visitation if father relationship ends?
No, because that relationship with father would be severed, but I think in a practical sense, I don't see that happening. So there was no significant interference with father's ability to communicate with the child and no significant discouragement in doing so. In fact, the evidence that the trial court found credible actually overwhelmingly establishes the opposite. So it just can't be said that the probate court clearly lost its way when it found that father failed without justifiable cause to have more than de minimis contact with the minor child. The record is clear, father had plenty of opportunity to communicate and build a relationship with the child, mother encouraged him to do so, and he chose not to for no other reason than not wanting to be father. So since father did that, his consent is not required for stepfather's adoption to proceed pursuant to revised code 3107.07a. So as such, we ask that the judgment of the probate court be affirmed. Thank you.
Thank you, counsel. You may proceed on the rebuttal. You will have 4 minutes and 29 seconds.
Okay, thank you, Your Honor. I'll be very brief anyway, just based off of some of the questions that Your Honor's asked. From a timeline perspective, the passport issue took place before the Walmart issue. So I would argue that it's reasonable to think the child would want to see her father at Walmart when she had been told that she couldn't go on a family vacation because he wouldn't sign.
Was that during the 1 year also?
No, it was prior.
The passport was prior to
I
that?
believe it was prior. It was in 2021. So it would have been like a little
indicated
bit.
that was the only request that was produced, it seemed to be on the record where your client asked for visitation. Is that correct to your knowledge? Was there other times he asked for visitation?
To my recollection, that is the only one that's verifiable on there, okay? In Your Honor, I think you asked the conversation about mother saying that she would tell the child is on transcripts at page 21 and 22 for your reference, to be able to review what the exact testimony was and make sure it's accurate. And since opposing counsel brought up the financial hardship, their argument is that financial hardship was just kind of an excuse or an after-the-fact thought by dad. However, I do want to point out that the trial court relied on that as part of their finding. Trial court actually made a specific finding. It appeared to be placing a burden on father to prove why he never went to court and asserted his rights, in that he could have afforded it and he bought this pool for his other children, and even opposing counsel said he never indicated that he was saving up money. The law very clearly states that there is no burden on the non-custodial parent to prove that they had a financial hardship and therefore could not go to court. They are not required to go to court or to modify. That doesn't have any legal effect as to whether or not mom was creating.
Did the client, and I appreciate your argument about the burden, did your client produce any evidence that he talked to attorneys or did anything or looked into filing in domestic relation court to start visitation?
No.
I have a question too.
Yes.
I want to go over the standard of review. Opposing counsel seems to say it is abuse of discretion for whether de minimis contact occurred, but weighed the evidence for justifiable cause in not allowing the visitation. What is your understanding of the standard of review?
Oh, yeah. Yeah, I picked up on that. I was like, my understanding is that it was all manifest weight. Although I don't have a real issue with abuse of discretion because it's a higher burden for me to get it overturned, but I thought it was all manifest weight position, but I could be mistaken there.
Thank you. Oh, I do have another question. What are we to do with the trial court's credibility determinations? Isn't that the main thing impeding you in this appeal?
I think it is, the credibility is definitely an impediment on this appeal, but I don't know that I would say the main thing, because I think that there is, I don't think it just has to be credibility. I think that there's enough information in the record to indicate that mother did. And keep in mind that when we're talking about whether or not there was justifiable cause, you're not restricted to the 1 year look back period. The law indicates that it can be taken over the course of that time. So I don't know that credibility is the issue. I think if you really look at the facts and recognizing that there are definitely some holes and some contradictions in fact, I think it's pretty clear that there were some very specific instances of mother prohibiting father from seeing the child, and, just go back to the case law says, any blockage. And there has to be, so I think the credibility, obviously, we all know that the standard of the trial court's in the best position to review the credibility of any witness, but I do believe that this court does have the ability to review that based on some of the other information in the record and determine whether or not it appears to be way off balance with what's actually taking place. Are there any other questions? Okay, then I would thank you for your time.
Thank you both for your presentations. The court will take the matter under advisement and will issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the web.